Yesterday afternoon, right around 4:47, something unusual happened in the offices tied to Donald Trump's legal operation. A heavy quiet settled in, not the kind where lawyers huddle to plot their strategy or draft statements for the cameras. No, this was the stunned hush of people watching their carefully built defenses crumble in an instant. Just under a day earlier, in the dead of night while most Americans slept, the U.S. Supreme Court dropped a ruling that hit like a thunderclap. It tore through the layers of protection Trump and his team had piled up over years of litigation. Claims of total immunity for a president? Gone. Arguments leaning on executive privilege? Dismantled. The endless motions to stall proceedings in multiple criminal cases and civil actions, suddenly without foundation. Think about the history here for a moment. Over more than 2 centuries of the Republic, has the Supreme Court ever dismantled a former president's legal barriers so thoroughly and decisively? Not under Nixon at the peak of Watergate, not during Clinton's scandals. No precedent exists for anything this sweeping. And here's the part that should make anyone sit up straight. The 3 justices Trump personally placed on the bench, individuals widely viewed as his strongest allies on the court, joined the decision against him without a single dissent. All 9 justices aligned in rejecting key elements of his position. If you're trying to make sense of how this happened and what it truly means for whether a former president could face real consequences, including potential prison time, stick with this breakdown. Mainstream coverage often skims the surface with quick headlines. The deeper mechanics reveal a far more serious unraveling, one the public discourse hasn't fully captured yet. The countdown is on. Trump's side reportedly has just 14 days to file a response to challenges his own attorneys have conceded are nearly impossible to overcome effectively. What hit the news wires is the main 63-page opinion, released publicly on the court site. Every outlet is parsing it now. But the real damage lies in the sharper judicial language embedded throughout. Federal benches have stopped pulling punches. The old courtesy reserved for executive branch arguments, it's vanished. Judges aren't just deciding cases against the administration anymore. They're building a lasting record in official opinions, documents that endure for generations, stating plainly that this government's assertions often don't hold up against reality. These aren't loose opinions or my interpretations. Court records show judges reviewing concrete evidence and concluding that statements from Trump-era officials frequently clash with verifiable facts, making broad trust in their accounts difficult at best. Information flows are messy these days, full of competing narratives. That's why digging into primary sources matters more than ever. Beyond the visible ruling, though, there's material few are talking about because access is tightly controlled. Court filings include a sealed section, around 47 pages of classified material, limited to involved counsel and necessary judges. People with close knowledge of what's inside point to one particular passage containing details so severe they could prompt swift referrals to multiple grand juries for further criminal scrutiny. To trace how this all unfolded, consider an earlier internal phase of the Supreme Court's work. Initial drafts reportedly included a strong dissent from Justice Clarence Thomas, some 32 pages defending broad absolute immunity for presidential actions. Justice Samuel Alito had attached his name, and Justice Brett Kavanaugh appeared ready to sign on as well. Drafts like these move among the justices routinely before anything finalizes. Then came January 8th. A classified session with Department of Justice officials changed everything. Whatever was presented in that briefing evaporated the dissent. The court coalesced around a unified position, rejecting Trump's core arguments. Recent decisions across federal courts go beyond isolated setbacks. Presidents lose lawsuits regularly. What's different now is the explicit wording judges choose when explaining why. They're not merely disagreeing on law. They're recording findings that administration positions misalign with evidence, sometimes contradicted outright by video or other objective proof. Take the situation in Illinois as a clear example. U.S. District Judge Sarah Ellis examined body-worn camera recordings and overhead surveillance from federal immigration enforcement actions. She compared those visuals frame by frame against official Department of Homeland Security statements about the same events. The mismatch was stark. Her written order described the government's account as filled with inaccuracies so profound that trusting their claims broadly became difficult, if not impossible. Pause on that phrasing. A sitting federal judge entered into the permanent record that she finds it hard to rely on almost any assertion from the defendants. That's no small procedural note. It's a core credibility assessment with wide-reaching effects. It signals that representations made to courts, even under oath, may not match documented events. The underlying dispute centered on clashes between protesters and federal agents during immigration operations. DHS filings asserted that demonstrators launched serious assaults using fireworks and stones. They described agents issuing repeated clear warnings before deploying tear gas, with significant time gaps. But the footage told another story entirely. Warnings amounted to roughly 5 seconds in many instances, barely enough time to register, let alone comply. No extended period of cautions, no massive barrage of projectiles as described. Judge Ellis responded with a broad directive sharply curtailing federal agents' ability to use force in protest settings. She grounded that restriction explicitly in the proven gap between what was claimed and what the evidence showed. This isn't a one-off rebuke. It's now part of the official judicial history, available for citation in any future matter where the administration's reliability comes into question. In a parallel case, U.S. District Judge April Perry addressed Trump's push to invoke rebellion provisions and federalize National Guard units for deployment inside Illinois. Over the governor's direct objections, the administration argued an ongoing insurrection demanded military intervention. Judge Perry scrutinized the supporting assessments from Homeland Security. She found them lacking any solid foundation for such an extreme claim. Evidence pointed instead to isolated vandalism, minor scuffles, and property issues, routine matters for state and local police, not grounds for troops on city streets. Her order halted the move cold. It climbed to the Supreme Court's emergency calendar. In a striking development, the justices declined to lift the block. They allowed Judge Perry's ruling to stand, denying the president authority to send federalized forces into a state against its leadership's will based on unsubstantiated rebellion assertions. This marks an uncommon defeat for executive military authority on domestic soil. Combine these outcomes, and the damage multiplies. Lower court judges openly question whether Justice Department attorneys can present accurate information. The Supreme Court itself steps in to halt major domestic security operations. The legal pillars Trump leaned on, broad immunity, unchecked emergency powers, are being chipped away, with courts explicitly noting discrepancies between official stories and hard proof. Some observers argue this steady accumulation of adverse findings inflicts longer-term harm than any single criminal trial. It erodes both personal trustworthiness and claims of near unlimited authority. Future litigation will inherit these records. Opposing counsel will reference them constantly. Judges will approach administration arguments with built-in caution. This pattern spans issues: immigration enforcement tactics, protest responses, military domestic use, even tariff justifications, and other executive expansions. Courts are signaling that emergency declarations require real factual backing, not just declarations of necessity. Returning to Judge Ellis's Illinois decision for clarity, federal agents faced public backlash during operations targeting undocumented individuals. DHS described violent attacks on personnel, justifying forceful crowd control, yet body cameras and aerial views showed otherwise. No widespread rock throwing or fireworks barrages. Tear gas followed minimal, near-instant warnings. Her conclusion: misrepresentation so fundamental that confidence in the government's word evaporates. The resulting limits on force stem directly from that distrust. If agents distort events when cameras roll, what happens off-record? Judge Perry's ruling tackled executive overreach more broadly. Invoking rebellion to override a governor and insert troops domestically is rare and demands strict proof. The evidence fell short, far short. Vandalism and sporadic confrontations don't equate to insurrection threatening federal authority. The Supreme Court's refusal to intervene on the emergency docket carries weight. They could have allowed deployment pending full appeals. Instead, they preserved the lower court block. Even this conservative-leaning bench drew a line around domestic military action. Legal experts highlight why these interconnected losses sting so deeply. Criminal probes target specific past behavior. These civil and emergency rulings shape ongoing operations and future authority. They build skepticism into the system. One judge's documented finding of unreliability influences others. The government starts every case at a disadvantage. Judges could rule against the administration while softening blows with neutral phrasing, acknowledging disputes without accusing bad faith. They're choosing stronger terms, misrepresentations, unreliable, detached from facts. That language echoes in media, briefs, hearings, and public debate. It lends judicial weight to doubts about honesty. The National Guard block carries extra significance. Trump appeared to view certain statutes as granting wide latitude to deploy forces domestically. The court indicated otherwise. Claims must rest on verifiable conditions. Courts will examine them closely. This creates a feedback loop. Factual unreliability weakens power assertions. Without credible grounds, extraordinary authority collapses. Key points to carry forward: Judge Ellis concluded video evidence directly contradicted DHS accounts of protest violence and force use, stating trust in administration claims is challenging or impossible. She restricted future force deployments based on proven misrepresentations, including exaggerated warnings when footage showed seconds at most. Judge Perry rejected rebellion claims for National Guard federalization, finding no insurrection, just standard disorder local authorities manage. The Supreme Court upheld that block, delivering a notable check on domestic troop authority. Analysts view this credibility erosion and power constriction as potentially more enduring than prosecutions, creating precedents that shadow every administration case. What does the bigger shift look like? Courts have moved past deferential treatment. No more automatic good faith assumption toward executive lawyers. Explicit findings of unreliability now appear in binding opinions. This ripples outward. Skepticism grows. Evidence demands rise. Contradictions trigger faster scrutiny. The Supreme Court's stand against the Guard move shows limits even this bench enforces on extreme claims. Domestic military powers aren't unlimited. Facts must align with legal thresholds. For those concerned about overreach, these decisions reaffirm checks and balances. Even Trump-appointed justices participate in reining in assertions that stretch too far. Trump's challenges mount simultaneously. Criminal matters, oversight probes, civil suits, now pervasive credibility issues touching all proceedings. Each layer compounds the pressure. These aren't temporary setbacks that spin away. They're etched in judicial records, detailed, cited, permanent. Prosecutors, committees, voters can point to them indefinitely. The dishonesty appears systemic, surfacing wherever claims meet verifiable evidence. Trump's aggressive agenda relied on expansive emergency interpretations. Courts insist on real predicates. Piece by piece, those foundations weaken. This doesn't end with incarceration on its own, but it strengthens every accountability avenue. A record of judicial distrust weakens public support, hampers obstruction, shatters perceptions of invincibility. The silence in Trump's legal circle yesterday afternoon echoed reality breaking through. Delay tactics, deflection, sweeping power claims hit firm limits in evidentiary standards. The rule of law asserts itself methodically. Governing through unverified assertions faces mounting resistance, not from politics alone, but from courts doing their job. The battles continue. New rulings emerge regularly, adding to the record of limits and credibility concerns. The pattern holds. Courts are defining boundaries around this presidency, and those lines matter. Stay alert. These developments shape the landscape far beyond any single case.